Oluwafemi
Oluwafemi Akinolu for the defendant.
Ekilolu, yes. Yes, Oju. Oju, the matter is for yes,
yes, my lord.
yes.
On the last adjourned date, I informed the court that the defendants had sent the full amount,
Yes.
in check form to the claimants, and they've all picked their checks, and also the terms of settlement has been signed.
Yes.
So it was left for we sent it back to the defense counsel, so it was left for them to do the necessary filing, and that is what we are here for.
No, he has filed.
Yes, my
Yes.
lord. Yes, my lord. He did inform me that we are yet to get the hard copy, which we are
Okay.
still expecting. He sent me a soft copy too.
Is dated and filed on the 30th of May.
Yes, my lord.
And briefly, my lord, I sincerely apologize for my absence at the last agenda. I couldn't make it back to the office for
She said you had a
to connect.
You wish to adopt it and urge the court to enter it as judgment?
Yes, my lord, exactly. That is what we're here for.
Consent judgment.
Yes, consent judgment. Yes, Mr. Femi, no objection.
Yes,
No
my lord. My lord?
Yeah.
No objection.
Okay.
No objection, my lord.
Okay, thank you.
The claimant counsel.
Thank you.
Subject to the convenience of the court, you can proceed and lay this matter to rest.
Okay. Please, can the other persons mute themselves so that we. Please, the other person that are not parties to this proceeding should mute themselves, please. It's like you're interrupting the proceedings. You should mute yourself. So, terms of settlement dated and filed on the 30th of May 2020, duly signed and adopted by the parties and the respective council, are hereby entered as consent judgment of this.
As the court pleases.
Yes, and it will apply to other cases.
Yes, my lord. Yes, my lord, exactly.
So, Mr. Femi and Oju.
Yes, my lord, as a court pleases.
Thank you so much. We are done with your case.
Thank you very much, my lord.
I'm most grateful to the court.
Thank you, my lord.
I appreciate the indulgence of the court.
Thank you.
Right. Thank you, my lord.
So, my lord, if I may, can I exit?
You can leave. Yes, you can leave. Thank you.
All right. Thank you, my lord. Thank you very much.
I'm grateful to the court.
Yes, other counsel in the case of Sodo, Unana, and Union Bank, lawyers in the matter.
Yes, my lord. Counsel to defendant.
Eh?
Counsel to defendant, Sodo, Unana, and Union Bank is present.
What about the counsel for the claimants? Counsel for the claimants.
One shot. One place.
Come here now. Come here. Stay here. Hello? You're hearing me. Just introduce
Can you get in touch with the counsel for the claimants?
He's talking to me. No, well, I am the claimant, the witness in the case.
You are counsel for the claimant?
I'm not a counsel. I'm the first claimant.
I'm not talking to you. I'm talking to a counsel, not to any litigant.
Sorry.
Okay, you are the first claimant. Hello?
Sorry?
You are the first claimant.
I'm the first claimant.
Okay, where is your counsel?
Well, he's supposed to be on. I don't know. I've not seen him.
Okay, maybe you can just proceed, huh? Since the first claimant is in court. First claimant. So how many claimants are in court? How many claimants are in court?
We are numerous. We are about 70, about 75.
75?
About
75 claimants?
About 75, yes.
Okay.
My lord, we have to proceed to announce my appearance.
Okay, just hold on. Yes, Mr. Yes, can you announce your appearance?
My name is Tajuddin Gani Kale.
Tajuddin?
Yes, Tajuddin Gani Kale. G-A Gani Kale spelled Ganikale is spelled G-A-N-I-K-A-L-E, sir.
Is it G-A-N-I?
Yes, sir. G-A-N-I-K-A-L-E.
Ganikale.
Yes, my lord.
So this is my judgment. Mr. Ganikale, the claimants, who are 1,799 in number, commence this suit by way of complaint and other accompanying processes filed on the 13th of December 2018 and ask for the following reliefs as contained in the statement of fact against the defendant. Number one, declaration that the conduct of the defendant in using stock applying UBN 2005 accrual valuation rather than 2008 accrual valuation in computing and transferring of the legacy benefit and contributory pension entitlements of the claimant to the various pension fund administrators, PFAs, is illegal, wrongful, arbitrary, overreaching, and constitute a violation of the provisions of the defendant's in-house defined benefit scheme, Union Bank of Nigeria's staff pension fund deed of variation of trust deed, and the contravention of the provision of the Pension Reform Act. Number two, a declaration that the failure or default of the defendant to promptly transfer the legacy benefit and to remit monthly contributory pension deduction of the claimants to their various retirement savings accounts as required by law, and its conduct in unlawfully, unilaterally, and whimsically and arbitrarily tampering with the pension asset of its employees by purportedly investing them without their knowledge, consent, or approval, and thereby occasion dissipation of the assets to the detriment of the claimant is illegal, wrongful, and a contravention of the provisions of the defendant's in-house defined benefit scheme and Pension Reform Act. Number C, an order directing the defendant to compute the legacy benefit and contributory pension entitlement of the claimant using stock applying UBN 2008 accrual valuation and to transfer same to the various PFAs in line with the provision of UBN, TD, and R and the Pension Reform Act. Number D, interest on the total sum of the defendant's commercial lending rate from 31st December 2015 till date of judgment, and thereafter at 30% per annum, the judgment date is liquidated. Number E, damages in the sum of 1 million naira only. Defendant upon being served with the originating process and in reaction to the claimant's suit, filed a statement of defense and other accompanying process on 26th of February 2019 via leave of court granted on 28th March 2019. The claimants also filed a reply to the defendant's statement of defense on the 11th of April 2019, and the case was afterwards set down for trial. Case of the claimants. From the pleadings filed by the claimant, the crux of their case is that they are ex-employees and senior staff of the defendant who resigned from the defendant or were retired by the defendant between 2007 and 2017.
Yes.
Employees of the defendant, claimants' pension benefits fall under the contributory pension scheme of the Pension Reform Act 2004, which mandatorily requires that the defendant as employer transfers to the claimant's various RSAs monthly payment of 15% of individual claimants' current monthly salary, which ought to take into account increase in the claimant's salaries. That under the Act, the defendant is under obligation upon transit from its in-house defined benefit scheme to the scheme under the Act to promptly transfer the claimant's legacy pension entitlements according to the individual claimants under the defendant's existing UBN trust deeds, as the Act requires any such already accrued benefits under any defined benefit scheme existing before its commencement to be transferred by the employer into the RSA of the employee. That in the event of any insufficiency of funds to meet the liability, the shortfall shall immediately become a debt of the relevant employer and be treated with same priority as salaries owed, and the employer should issue a written acknowledgement of the debt and take steps to meet the shortfall. The defendants sometimes in 2012, 2013, and 2015 unilaterally did bulk transfers of their legacy benefits and contributory pension entitlement into the claimant's various PFAs, which is a clear indication that legacy entitlement of the claimants under the defendant defined benefit scheme was not transferred by the defendant into the RSAs as required by the Act. Neither was the obligatory prompt monthly remittance of 15% into the various RSAs complied with by the defendant, whilst they were in the defendant employed. But in the transfer of their legacy and contributory pension benefits to various PFAs by the defendant, claimants' entitlements were grossly underpaid by the defendant in that taking subterfuge under a concocted and contrived memorandum of agreement, the defendant, rather than use to apply UBN 2008 actuarial valuation in the computation of their legacy and contributory pension benefits, conveniently chose to use UBN 2005 actuarial valuation parameters, which is known to the defendant not to be a true reflection of the claimant's legitimate entitlement as at the time of their exit from the defendant, and thereby arrived at a grossly lower computation of the claimant's legacy and contributory pension entitlements. Now, the conduct of the defendant in using or applying UBN 2005 actuarial valuation rather than 2008 actuarial valuation in computing and transferring of the legacy benefits and contributory pension entitlements of the claimant's various PFAs overreached the claimants and deprived them of their accurate and legitimate entitlements as increases in the claimant's monthly salary post year 2005, which ought to be reckoned by the defendant in the computation was not countenanced. The policy of the defendant on staff salary and pension benefits changed since year 2005 in that prior to year 2005, emphasis was on low-scale monthly salary but high pension benefits under the defendant in-house existing pension scheme, which scheme was wholly funded by the defendant. However, post 2005, the defendant's policy changed to high-scale staff salary as issue of pension benefit of serving staff was no longer wholly funded by the defendant, having been overtaken by the contributory pension scheme provision of the Act, which made the issue of pension entitlement a product of the cumulative contribution of the employee, of the employer, and the employee. that shocked by the grossly low transfer made into the various PFAs by the defendant, claimants came together under the umbrella of the Association of Contributory Pensioners of Union Bank of Nigeria, and through correspondence demanded a redress from the defendant. And when the defendant was not forthcoming, claimants also, through their state association, wrote a complaint to PENCOM for a redress. That PENCOM, by a letter dated 12 September 2017, responded to the claimants association's said letter and attached thereto photocopies of correspondence, 5 letters dated 22nd May 2008, 28th January 2010, 23rd March 2010, 22nd 9 2015, and 21st February 2016. Earlier exchange between it, PENCOM, and the defendant in respect of the subject matter. From one of the attachments to Exhibit C27, defendant's letter dated 22nd March 2010 to PENCOM, claimants got information that the defendant in the letter clearly stated that it exited its in-house existing pension scheme in 2008 and thereby fully transited into a contributory scheme created under the Act. Defendant said letter of 22nd March 2010 was a response to PENCOM's letter to it dated 2nd May 2010 and 28th January 2010. Claimants also gathered from other attachments to the letter that PENCOM had carried out on-site examination of the defendant. Respect to the defendant pension asset, and had also in its letters queried the defendant's failure to comply with the provision of the Act and demanded compliance by the defendant in the matter of the pension entitlement of its employees, including the claimants. In the letter of 22nd of May 2008, PENCOM, amongst others, conveyed to the defendant that if PENCOM conducted on-site examination of the defendant on 5/5/2008, sequel to the defendant letters of 31st March 2008 and 29th April 2008, with respect to compliance by the defendant with the provision of the Act, and based on its findings from the examination and the review of the actual valuation by HR Nigeria Limited, it PENCOM established that as at the date of examination, 5/5/2008, a total of 6,748 employees of the defendant were yet to open retirement savings account with any pension fund administrator. Furthermore, in the letter, PENCOM also conveyed that it established that the actual valuation as at 31st March 2008 revealed that the defendant's staff pension scheme had an accrued liability of 42 billion and pension asset worth 46 billion. The accrued rights of active staff being 27 billion, while the actuarially determined liability to existing and deferred pensioners was 15 billion. That based on its said findings, PENCOM directed the defendant to, number one, ensure that the 6,748 active staff are not restricted to any pension fund administrator, but are allowed to open their retirement savings account with any PFA of their choice. And B, transfer the accrued rights of the active staff amounting to 26 billion to the employee's retirement savings account. And C, transfer the accrually determined liability to existing and deferred pensioners of 15 billion to licensed pension fund operators for management and custody. And D, on the staff duty scheme and transfer the assets to licensed operators for management and custody. PENCOM further directed the defendant to forward to it evidence of compliance with its directives and threaten appropriate sanctions in the event of failure by the defendant to comply. Claimants also gathered from another attachment to the letter from PENCOM, from PENCOM's letter of 28th January 2010, captioned transfer of Union Bank legacy pension assets to the defendant. A letter PENCOM wrote to the defendant further to defendants transfer of 30 billion naira legacy pension assets, Premium Pension Limited and ICO Pension Managers Limited, and observed therein that the defendant did not indicate whether the asset belonged to the existing pensioners or active employees. Furthermore, PENCOM observed that the legacy asset of the defendant pension scheme, as indicated in the actual valuation of March 2008, was 46 billion naira, and the defendant was yet to transfer the remaining asset amounting to 16 billion to the custodian of the defendant's appointed pension fund administrators. In the said letter, PENCOM observed that the defendant was yet to provide evidence of transfer of the accrued right of the 6,748 active staff, totaling 26 billion naira, to the retirement savings account, and conveyed to the defendant that its failure to transfer the outstanding legacy pension assets to licensed operators and conclude the transfer of the accrued right constituted a violation of the provisions of Pension Reform Act. Consequently, PENCOM required the defendant to provide evidence of transfer of the remaining legacy pension asset worth 16 billion, as well as the accrued right of 26 billion to the defendant's employees' retirement savings account in line with its directives. Claimants also gathered that the defendant in its response dated 22nd of March 2010 stated among others that following the actual valuation of its legacy pension funds by its actuaries in May 2008, it transferred 30 billion to the two pension fund administrators appointed by it, i.e. Premium Pension and ICO, and that the funds transferred to legacy PFAs represented contribution by the defendant in respect of its retired and eligible active staff. Furthermore, in the defendant's said letter, the defendant stated that based on its actual valuation of March 2008, assets amounting to 16 billion were not transferred, and that retention of some of the assets was to facilitate the continuous payment of retired staff still being undertaken by the defendant pending when the whole scheme is closed out. The defendant stated further that the March 2008 valuation also required that it transferred 26 billion to the retirement savings account of 6,748 active staff as at the end of March 2008. The claimant's contention that the defendant did not discontinue its in-house pension scheme till 31st December 2008. Hence, the defendant ought to have applied UBN 2008 actual valuation in the computation of the claimant's legacy benefits and contributory pension entitlements, rather than conveniently choosing at its date to apply UBN 2005 actual valuation parameters, which is known to the defendant not to be a true reflection of the claimant's accurate and legitimate entitlement as at the time of their exit from the defendant. Claimant also contend that the conduct of the defendant in not applying the UBN 2008 actual valuation is a flagrant violation of the protective provisions of the Act designed to guarantee and secure their entitlement, and consequently, the claimants have been overreached by the defendant. Claimants further contend that the poor discretion exercised by the defendant in investing its employees, including the claimant pensions asset, in one asset type shares with high volatilities without their knowledge, consent, or approval, resulting in a huge shortfall in assets relative to the scheme's liability. Total assets as at 31st of March 2009, which represented a loss of about 46 billion of the scheme asset, 49% of the scheme asset, a loss which could have been avoided had the defendant not unlawfully and for its own gain tampered with the pension asset of his employees. Finally, claimants contend that the defendant having plunged the pension asset of his employees, including the claimants, into an avoidable dissipation, rather than make up for the shortfall as required by the Act, conveniently contrived and concocted a memorandum of agreement purportedly Union Bank Pension Association and stakeholders to provide it a cheap escape from a self-foisted liability. That when the defendant failed to refuse to redress the issue as demanded by the claimants, the defendant should compute and transfer to the claimant's various PFAs their accurate and legitimate legacy benefits and contributory pension entitlements using applying UBN 2008 actual valuation in line with the provisions of UBN TD and R and the Pension Reform Act. Then claimants instituted this action seeking the reliefs as stated above. Case of the defendant. It is the case of the defendant from his statement of defense that the claimants left the defendant's employment at various times up to 2017. And as at the time of their respective exit from the defendant's employment, the claimants fell under the contributory pension scheme under the Pension Reform Act, which was subsequently amended in 2014. But according to the defendant, sometime before the claimant's respective exit from the defendant employment, the defendant from January 2006 started making pension deductions from the claimant's monthly remuneration, in line with the contributory pension scheme under the Pension Reform Act. That whilst commencing the said deductions under the contributory pension scheme, the defendant meanwhile applied to the National Pension Commission for license to operate as a closed pension fund administrator under Section 39 and 40 of the Pension Reform Act. Under Section 39 and 40 under the Pension Reform Act, during the pendency of the said application to PENCOM, the defendant did not transfer the claimant's accrued legacy pension and the contribution made under the contributory scheme. That when the defendant could not meet the conditions stipulated by PENCOM for the grant of the license to operate, the defendant commenced the process of transferring the employee's pensions, which had accrued under the in-house scheme as at the date of commencing the contributory scheme, and plus the contributions which had accrued under the contributory pension scheme from the date of commencement of the said contributory scheme. The defendant has paid the statutory penalty for the late remittance of the contributory pension and interest at Treasury bill rate for the late remittance of the accrued in-house pension. That accrual valuations are projections which are based on assumptions, and the assumptions used for the 2008 valuation were wrong. Trial in this case had initially commenced on 13th of November 2019 before Honorable Justice Asian. But upon his transfer, the matter commenced de novo, and the first claimant on the 14th of July 2021 testified by adopting his true statement on oath and tendered exhibits C1 to C28. TW1 was thereafter cross-examined by the Land Council to the defendant, and as there was no re-examination, TW1 was discharged, claimant's case was subsequently closed, and the matter was adjourned for defense. Defendant opened its defense on 7th of October 2021 and called Mr. Jimmy Mokikan as his witness. He adopted his statement on oath and tendered exhibit UBN 1 to UBN 6. DW1 was cross-examined, and as there was no re-examination, he was discharged, and the matter was adjourned for continuation of defense. On the date fixed for continuation of defense, Exhibit UBN 7, 8, and 9 were tendered by learned counsel for the defendant from the bar. And as there was no objection, documents were admitted accordingly, and the matter was adjourned for adoption of final written addresses. Defendant's final written address. Defendant's final written address filed on the 18th of November 2021 was deemed as properly filed and served following leave of court to that effect. Final written address contains 4 issues for termination to it. Number 1, having regards to the state of evidence before the court, where the claimants have shown that their pension entitlements were underpaid by the defendant. Number 2, having regard to A, payment of interest at treasury bill rate for the late remittance of the accrued in-house pension and the payment of statutory interest for the late remittance of the contributory pension, whether the claimants have not been compensated for the delay in the remittance of both the accrued in-house pension and the contributory pension. Number 3, whether reliance can be placed on the 2008 actual valuation in determining the claimant's accrued in-house pension. Number 4, whether CW1 is a credible witness whose testimony can be relied upon by this honorable court. Under counsel for the defendant submitted on issue 1 that the substance of the claimant's case before the court is to the effect that the defendant allegedly underpaid the claimant's pension benefits, that it is elementary law that he who asserts has a duty to prove the assertion. Counsel cited the case of Sharing Cross Educational Services Limited and Umaru Adam Enterprises. And the counsel also submitted that there is no iota of evidence before the court to show how much each of the claimants was paid, how much each of them ought to be paid, and how much is the alleged shortfall. That's the difference between the amount they were actually paid and the amount which they allegedly ought to have been paid. And the counsel further submitted that under cross-examination, CW1 testified that pension under the UBN pension trust deed is determined on the basis of basic salary, transport allowance, housing allowance, and lunch allowance. He further testified that years of service are also a relevant metric in computing pension benefit under the PTD. Counsel argued that the implication of the said testimony by CW1 is that the pension benefit of each of the claimants is objectively calculable, that each of the claimants knows his or her basic salary, transport allowance, lunch allowance, as well as his or her years of service at the time of exit. Counsel also argued that no evidence was laid by the claimant as to any of the said metrics, that under cross-examination, CW1 testified that he does not know the claimant's retirement / exit dates or their respective years of service. Now, this court cannot arrive at a decision of the amount due to each of the claimants or a decision as to whether or not the payment made to each of the claimants fell short of the said due sum. But none of the claimants tendered his RSA statement of account to show how much he or she received, and no evidence whatsoever was given in that regard for the claimants. Another counsel further submitted that before the claimants can be said to have been underpaid their accrued in-house pension, there has to be positive evidence before the court showing the following. Number 1, the amount which each of the claimants is entitled to, which sums should be computed in accordance with the metrics / formula stipulated under the PTD. And number 2, the amount which was actually paid by the defendant, which evidence resides in the claimant's respective RSA statement of account. Number 3, the evidence of 1 and 2 above will then reveal if there was indeed an underpayment and by how much, if any. It was the argument of counsel that no such evidence as required under 1 and 2 above has been laid before the court. Arguing further, counsel stated that the same abject lack of evidence applies to the contributory pension. The CW1 testified in his evidence in chief that the contributory pension is based on 15% of the monthly salary of each of the claimants, and each of the claimants knows his or her monthly salary during the relevant period between the commencement of the contributory scheme in 2006 and the claimant's respective exit from employment. Thus, each of the claimants can, by simple arithmetic, compute the aggregate of his monthly contributory pension over the relevant period as follows: 15% of monthly salary multiplied by the number of months spent in service from 2006 till exit date. They submitted that no shred of evidence was laid on the following: as to the monthly salary of each of the claimants over the relevant period, as to the employee's years in active service after the commencement of the contributory reductions in January 2006, or as to the cumulative contributions of each claimant from the commencement of the contributory scheme up to exit, or as to the actual amount that the defendant remitted into each of the claimant's retirement savings account and the cumulative contributions for each claimant. That in the absence of this pieces of evidence, this court cannot be expected to arrive at a determination on whether the claimants were unpaid their contributory pension and by how much they are underpaid. Counsel submitted further that the claimants have placed reliance on 2008 actual valuation report in asserting that their pension benefits were underpaid. That the table on page 2 of exhibit UBN2 shows that the accrued pension for active staff as at March 2008 stood at the sum of 26 billion. The same table shows that the number of active staff as at that date was 6,748. However, the number of the claimants in the instance case is 1,789. Thus, the said 26 billion applies to all 6,748 active staff and not just the 1,789 claimants hearing. That the question then is how much of 26 billion belongs to the claimants hearing. Counsel submit that the claimant did not leave any shred of evidence showing what portion of the said 26 billion allegedly belongs to them. Still on the question of the claimant's share of 26 billion, in paragraph 2 of the CW1 statement on oath, he testified that the claimants left the defendant's employment between 2006, 2007 to 2017. Under cross-examination, he stated that he left the defendant employment in 2015, while the other claimants left between 2007 and 2017. Counsel submitted that what is clear from the above testimony of CW1 is that as at March 2008, some of the claimants hearing were no longer in the defendant's employment. He further testified that he does not know those who retired in 2007. However, CW1 further testified that he does not know which of the claimants left in 2007. It was submitted that from the said pieces of evidence, it becomes clear that some of the present claimants were not active staff as at March 2008 and cannot therefore lay claims to any share of the stated 26 billion. But more interesting in the fact that this honorable court cannot speculate as to how many of the claimants fall outside the category of the active staff as at March 2008. That is the number of those whom CW1 has testified to have exited in 2007. Defendant contended that on the strength of the evidence before this honorable court, only CW1 has proved to be an active staff as at March 2008. That for all intents and purposes, and by all and any and all the other claimants could belong to the category of the claimants who were said to have left in 2007. Counsel submitted that it is tried that courts do not deal in speculations. Every court of law is bound to act solely on the basis of fact proved before it, and urge the court to hold that the claimants have failed to lead any evidence by which the court will arrive at a finding that their pension benefits were underpaid. Relying on the case of Akibon and Ita, where the court held that it is dangerous for this court to so speculate in the absence of evidence. After all, the court of law cannot speculate or conjecture. Also referring to the case of Okonji and Njokama. The other counsel also submitted that it is noteworthy that claimants' claims are based entirely on communications exchanged between the defendant and PENCOM between 2008 and 2010. However, there is ample evidence before the court which show the following. After the communication exchanges between the defendant and PENCOM in 2008 and 2010, on which the claimant's claims are entirely predicated, several meetings or engagement were held between PENCOM and the defendant, and the various staff unions wherein the issues contained in the said exchange of 2008-2010 were fully integrated by all the parties, including the same PENCOM who highlighted the issue in the first place. According to the meetings referred to in Exhibit UBN 3, the defendant complied with all the outcomes and resolution reached at the said meetings by compensating fully for the statutory infractions, following which PENCOM issued certificate of compliance referring to Exhibit UBN 7, 8, and 9. To the first submission of counsel that the claimant's claim been founded solely on the earlier findings of PENCOM as communicated by PENCOM to the defendant, and the subsequent statement certificate issued by PENCOM showing that the defendant has since fully complied with the act are sufficient proof that there is no other obligation owed by the defendant to the claimant in respect of their respective pension benefits. Counsel contended on issue 2 that the law is tried that where there is a wrong, the law and the court has a corresponding duty to provide a remedy. That in the instance case, the defendant has admitted both in its pleadings and under cross-examination that following the cessation of the in-house pension scheme in 2008 and the commencement of the contributory scheme in January 2006, the defendant failed to comply with the requirements of the law by failing to immediately transfer the accrued in-house pension benefits of each of the claimants and failing to immediately remit the monthly contributions for each of the claimants. It is therefore counsel's submission that the law has made ample provision for the remedy accruing to an employee whose contributory pension benefits are not immediately transferred and or remitted as required by the Pension Reform Act. Counsel referred to Section 11 sub 7 of Pension Reform Act 2004 being the operative statute at the relevant time. Counsel also referred to paragraph 10 of the claimant's reply to the statement of defense, where the claimants concluded the paragraphs as follows. Only interest paid by the defendant was for its delay in remittance of the 15% contributions, and this was done by the defendant under compulsion by PEMCON. Another counsel urged the court to note that the said admission was further reiterated in paragraph 14 of the claimant's reply to the statement of defense, as well as in paragraph 10 and 14 of CW1's additional statement on oath, that the law is firmly established that a fact which has been admitted requires no further proof. Relying on the case of Okereke and the state, and Indayako and Antoro, the mission of counsel that the said averments constitute an admission by the claimant to the fact that the defendant has already complied with the requirement of Section 11 of the Income Reform Act and owes no further liability to the claimants in respect of the late remittance of the claimant's contributions under the contributory pension scheme. Counsel submitted that with respect to the late remittance of the accrued legacies, it is instructive to note that from the outset, the Pension Reform Act does not stipulate the payment of penalty or interest for the late remittance of the accrued legacy in-house pension. However, pension in its wisdom and PEMCOM in its wisdom and pursuant to its powers under the Act, mandated that the defendant must pay interest at Treasury bill rate on the legacy pension accrued as at 2005. Counsel referred to page 4 of the minutes of meeting dated 24th July 2013 and exhibit UBN 6A and B. Counsel submitted that with respect to the CW1, the said exhibit UBN 6A and B reveal the payment of interest at Treasury bill rate in the sum of 106,000 respect to CW1 accrued legacy pension of 590,000 naira. With respect to Mr. Ibrahim Aliu Ondeku, listed as CW1 in the claimant's list of witnesses dated 13th December 2018, said exhibit UBN 6A and B reveal the payment of interest at Treasury bill rate in the sum of 2,240,000 naira in respect to his accrued legacy pension of 1,480,000 naira. With respect to Mr. Barnabas K. Osu, listed as CW1 in the claimant's list of witnesses dated 13 December 2018, said exhibit UBN 6A and B revealed the payment of interest at Treasury bill rate in the sum of 11,500,000 in respect of his accrued legacy pension of 7,599,000 and 98,000 naira. It is counsel's submission that the said piece of evidence stands uncontroverted, that the claimant did not lead any contrary documentary evidence to refute the payment of the said interest with respect of the late remittance of the accrued legacy in-house pension, that the claimant did not even tender the of account in respect of the respective retirement savings account, which they maintain with their various pension fund administrators, a rebuttal of the defendant's averment. Stating further that DW1 who testified as to the payment of interest to the claimants at Treasury bill rate was not cross-examined, and that the law is clear that the court is confronted with concise and corroborating testimony on the point that testimonies are not discredited, challenged, or repeated from under cross-examination. It will accept, lie, and referring to the case of Relatives and State, Akimumi and Idowu, Bello and Emeka, Lawani, and Komoro Aziz and the state, and broadline interference and operation.
It's one class for children. What did you say?
Please allow me some. Let me put on the television.
No, I'm just putting number 3. Oh, I just read that just to make number 3. I have to do all this again.
Come on, look at your book. So, what's this book?
Clement's final.
I got to collect it from Benin.
Who has these books? Is it your own?
No. I just collect it from Cookie. That's my own.
Yes, please, so people are interrupting the proceedings.
Seriously?
Then Clement's final written address. Clement's final written address was filed on the 3rd of December 2021, and it contains one issue for termination to it, and I quote, "Further from the evidence before the court, the defendant complied with the provisions of the Pension Reform Act as required in the computing of and transferring of the legacy benefits and contributory pension entitlements of the claimants to their various pension fund administrators. And if the answer is in the negative, whether claimants are not thereby entitled to relief sought in this action. Counsel for the claimants submitted that the crux of the claimant's case centers on the defendant's deliberate failure stroke refusal to comply with the provisions of the Pension Reform Act, computing and transferring of the claimant's legacy benefits and contributory pension entitlements to their various pension fund administrators, which conduct occasioned the wrongful withholding of the claimant's legacy benefits and contributory pension entitlements and dissipation of same by the defendant, resulting in the schemed underpayment of the claimant's entitlement by using a concocted and contrived memorandum of agreement. Claimant further submitted that under the PRA, the defendant is under obligation upon transit from its in-house defined benefit scheme to the scheme created under the Act to promptly transfer claimant's legacy pension entitlements benefits already accruing to the individual claimants under the defendant's existing UBN trust deed, as the Act requires any such already accrued benefits under the defined scheme existing before its commencement to be transferred by the employer into the RSA of the employee. It is submission of counsel that the defendant sometimes in 2012, 2013, and 2015 unilaterally did bulk transfers of the claimant's legacy benefits and contributory pension entitlement into the various PFAs, which conduct is a clear indication that their legacy entitlements under the defendant's defined benefit scheme was not transferred by the defendant into their RSS as required by the PRA. Neither was the obligatory prompt monthly remittance of 15% into the various RSS complied with by the defendant. while they were in the defendant employment. Counsel argued that in the computation and transfer of their legacy and contributory pension benefits to their various PFAs by the defendant, claimants' entitlement were grossly underpaid by the defendant, purporting that it existed in-house pension trust deed on 31st of December 2005, and consequently its legacy pension scheme terminated on 31st 2005, and chose to use to apply UBN 2005 actual valuation parameters rather than apply UBN 2008 accrual valuation. Let me just skip it to go through directly to my opinion. So this is my opinion. Having carefully perused the pleadings filed by the parties, the evidence presented, and submission of their respective counsel, I note that the defendant and the claimants in their final written addresses submitted 4 issues for determination and 1 issue respectively. But I think the issue of whether the claimants have proved their case to be entitled to the relief sought will be apt from the pleadings and avowed evidence before the court. Claimant's case is that they are former employees of the defendant who exited the bank under different circumstances between 2007 to 2017, but that the defendant did not comply with the provisions of the Pension Reform Act in computing and transferring of the claimant's legacy benefits and contributory pension entitlement to the various pension fund administrators, thus resulting in a schemed underpayment of the claimant's entitlements. That following the cessation of the in-house scheme in 2005 and the commencement of the contributory scheme in January 2006, the defendant failed to comply with the requirement of the law by failing to immediately transfer the accrued in-house pension benefits of each of the claimants and failing to immediately remit the monthly contribution for each of the claimants. But the defendant, sometimes in 2012, 13, and 15, unilaterally did bulk transfers of the claimant's legacy benefits and contributory pension entitlement into their various PFAs, which conduct is a clear indication that their legacy entitlements under the defendant's defined benefit scheme was not transferred by the defendant into their RSS, as required by the PRA. Neither was the obligatory front monthly remittance of 15% into the various RSS complied with by the defendant while they were in the defendant employment. The conduct of the defendant in using applying UBN 2005 actual valuation rather than 2008 actual valuation in computing and transferring of the legacy benefits and contributory pension entitlement to the claimant's various PFAs overreach the claimant and deprive them of their accurate and legitimate entitlements as increases in their claimant's monthly salary post-year 2005, which ought to be reckoned by the defendant in the computation, was not countenanced. The policy of the defendant on staff salary and pension benefits changed since year 2005, in that prior to the year 2005, emphasis was on low salary, high pension benefits under defendant in-house existing pension scheme, which scheme was wholly funded by the defendant. However, post 2005, the defendant's policy changed to high-scale staff salary as issue of pension benefits of serving staff was no longer wholly funded by the defendant, having overtaken the contributory pension scheme provision of the Act, which made the issue of pension entitlement a product of the cumulative contribution of the employer and the employee. The defendant, on the other hand, contended that it has already complied with the requirement of Section 11 of PENCOM Reform Act and owes no further liability for the late remission of the contributions under the contributory pension scheme, and that with respect to the late remittance of the accrued legacy in-house pension, it argued that the Pension Reform Act does not stipulate the payment of penalty or interest for the late remittance of the accrued legacy in-house pension scheme. The first and second relief sought by the claimants are declaratory in nature, and same can only be proved by credible and reliable evidence. See the case of Nayasum and Peter Side. However, I shall come to the issue of declaratory reliefs anon. Meanwhile, the third relief is for an order directing the defendant to compute the legacy benefit contributory pension entitlement of the claimant by using applying UBN 2008 actual valuation. The fourth and fifth reliefs are for pre and post judgment interest and damages as well. For the time being, I shall consider the third relief. And in considering that, I need to emphasize that the law still in place is that he who alleges must prove. And in the instance case, the burden lies on the claimants to prove that they are entitled to their claim with regards to the contributory pension scheme and accrued legacy in-house pension. Claimants allege that the monthly pension of 15% of their entitlements under the contributory pension scheme ought to take into account increase in the claimant's salaries. Meanwhile, the claimant under any defined benefit scheme existing before the commencement of the Act shall immediately become a debt. The claim under the defined benefit scheme existing before the commencement of the Act shall immediately become a debt and be treated with same priority as salaries in the event of any insufficiency of funds to meet the liability. It was stated further by the claimant that remedying of the breaches committed by the defendant would only be achieved by the defendant by recomputing the entitlement of the individual claimants using applying defendant's 2008 actual valuation, Exhibit 2, subtracting the payment based on the 2015 actual valuation already made to the claimant, computing the interest and penalties on the difference, and paying the difference between 2008 actual valuation and 2015 actual valuation figures into the PFAs of the respective claimants. In any event, and for short, the claimant's claims are for entitlements, and a claim for entitlement being monetary sum is a claim for special damages. The tax therefore lies on the claimants to prove their specific claims, but for provision of Section 131 of the Evidence Act, it is the duty of the claimant who asserts the existence of a legal rights that must prove that those facts exist. In the case of VP Industry Limited and Cocoa Industry Limited, the court held that the burden of proof in all cases raised on the person who asserts. The claimants are required by law to plead and support what they have pleaded by credible and convincing evidence, and that evidence should preponderate in civil matters before their claims can be acceded to by the court. And where they fail to discharge the honors, their claim must fail. See the case of Hamza and Kuri. See the case of Hamza and Kuri. To prove an entitlement, as in the instance case, the claimants must refer the court to the exact provision of the law, instrument, or document that confer the entitlement. See the case of Mohammed and Dungus. Here, it is the evidence in chief of CW1 that the last and final payment in bulk that was made by the defendant into the claimant's various PFAs was sometimes in 2015. And it was then that they became aware of the amount paid at their legacy and contributory pension benefits. CW1 also testified that increases in the claimant's monthly salaries post-year 2005, which ought to be reckoned by the defendant in the computation, was not countenanced. Claimants in support of this pleaded and relied on notice of salary review of some of the claimants. It was survived by CW1 that the contributory pension scheme benefits required to be transferred by the defendant is 15% of the current monthly salary of individual claimants. It is also essential to refer as well to the evidence of CW1 under cross-examination that pension under the UBN pension trust deed is based on total emolument, which includes basic salary, transport allowance, housing allowance, and loans allowance, and that years of service are also important parameters in computing pension benefits under the PTD. The law is that evidence has to be laid before an award for special damages is granted. And to succeed in a claim for special damages, it must be claimed specifically and proved strictly. The fact that it appears to be admitted does not relieve the party claiming it of the requirement of proof with compelling evidence. See the case of NNPC and Clifton Nigeria Limited. The burden is therefore that.
Okay, now the lawyer be this. Lawyer one last. Lawyer come and sọ̀rọ̀ down. Tó ti ṣe tẹ́lẹ̀.
The burden is therefore that of the claimants to prove to the satisfaction of the court the assertions contained in their pleadings. But the failure of the defense to prove their defense or testify cannot absolve the claimants of his primary duty. See the cases of Oyeni and Akinkube, Lawrence and Odubemi. The claimants still have the evidential burden to establish their claims for special damages with precision and not rely on the weakness of the defense. See the case of Okedare and Adebara. The party must only rely on the weakness of the defense to prove his case, while the case of the defendant supports his case. See the case of Eze and Atasi, and Shitu and Fashowe. Following from the above, and bearing in mind the evidence of CW1, I find that the claimants have not been able to present before the court their various pension funds administrators' account to enable the court see how much was paid to each of the claimants and how much was supposed to be outstanding. I also need to say with regards to increases in the salaries of the claimants that were alleged to have been reckoned by the defendant, that were alleged not to have been reckoned by the defendant in the computation of their benefits, that notice of salary review of some of the claimants, XBC 3 to 616, cannot represent or suggest that other claimants' salaries were also increased. I think failure of the claimants to present the notice of increase of salaries in respect of other claimants would only compel the court to find that there are no increase of salaries with respect to those other claimants. I've also earlier noted the evidence of CW1 that defendant's pension trust deed is based on total emolument, which includes basic salary, transport allowance, housing allowance, and lunch allowance. And the years of service are also important parameters in computing pension benefits under the PTD. However, the claimants have also not been able to present to the court any instrument or document conferring those allowances on each and every one of the claimants. I also find that each claimant's years of service are not pleaded, nor found in the entire process filed by the parties. And going by the above, I think claimants relief number 3 ought to be dismissed, and I so hold. For the declaratory reliefs, they always appear to be hard nut to crack. They are not just granted for asking or as a matter of course. They must be strictly pleaded and proved by credible evidence, which has to be led and proffered by the claimant to suspension and discretion of the court. It needs to be emphasized that a declaratory relief is one that seeks the pronouncement of the court as to the status of a named matter, thing, or situation. A claimant seeks the court to declare as established a legal and factual state of affairs in respect of the course of action. And he does no more than invite the court to declare what the position of the law is on the issue. Thus, in a declaration, the claimant must call evidence that will satisfy the court declaration sought. Law is settled that declaratory reliefs cannot succeed even on admission by the opponent. Reason being that a declaratory action is discretionary in nature. It is a species of civil action whose purpose is to seek an equitable relief in which the claimant prays the court in the exercise of its discretionary jurisdiction to promote or declare as existing state of affairs a law in his favor, as may be discernible from the above-mentioned of claim or pleadings from the parties. Hence, the onus of proof here lies on the claimant. He must succeed on the strength of his own case, not rely on the weakness of the defense, except where the case for the defense supports the claimant's case. Declarations are equitable relief, and so the parties seeking such must present the materials upon which the court will act to so declare. That's why admissions and pleadings cannot be the basis for declaratory reliefs. See the case of Akande and Adisa, AG Cross River and AG Federation, Buhari and Obasanjo, Omishore and Arabe Shola. Claimants in seeking the declaratory reliefs contended that the defendant did not use to apply 2008 actual valuation, rather illegally and wrongfully used 2005 actual valuation. However, the defendant averred in defense that actual valuation is a yearly exercise which is carried out by the defendant to determine its projected liabilities and its current asset for the purpose of determining its performance. It was also averred that the actual valuation is based on certain assumptions, such as the present number of employees, their earnings at the time of valuation, projected future earnings of the employees, inflation, retirement, age, and others. In the said actual valuation Exhibit 2, it can be observed the accrued pension for the active staff as at March 2008 stood at the sum of 26 billion naira. And the number of active staff as at that date was 6,748,000. That the said 26 billion naira applies to all 6,748 active staff, including the 1,789 claimants hearing. Question that beg for answer is how much out of the 6 billion naira that applies to 6,748 beneficiaries will be given to the claimant in this case. Even if the portion of the claimant entitlement is made clear and specific, then how much will each and every one be entitled to? How much was paid collectively and individually to the claimants by using the actual valuation of 2005? I find that there's no evidence as to what claimants or each and every one of them is entitled to out of the 26 billion naira. I should also say that it's not just good enough for the claimant to pass the buck to the defendant by asking to recompute the individual entitlements, subtract the payments already made to them, compute the interest and penalties on the difference, and pay the difference between 2008 actual valuation and 2015 actual valuation. But the claimant should go further to prove the individual share in 26 billion naira by credible and compelling evidence. I think based on this, the declaratory relief sought by the claimant should not be granted, and I so hold. Having resolved the mere reliefs against the claimant, I think the consideration of other reliefs becomes unnecessary and will serve no practical purpose. The foundation of the case having collapsed, there is nothing left upon which it is to stand. Therefore, reliefs 4 and 5, interest and damages, are necessarily declined. On the whole, and for the reasons as contained in this judgment, the claimant's case fails and is hereby dismissed, as they have not been able to prove their case by cogent and credible evidence. Mr. Tajuddin.
My Lord, we have to thank you for God consider judgment. Your Lordship has applied law as it is, and we will pray that God continues to increase the wisdom of my Lord. My Lord, this is justice, and we are most grateful. Thank you, my Lord.
Thank you. So, Mr. Tajuddin. Mr. Tajuddin.
Yes, my Lord.
That will be all for today. And I wish you a very good evening. And also some any other things. Yes.
Case is over.
Thank you, my Lord. Please call him. Wow.
My Lord. Hello, my Lord.
I've lost. We have a new evidence according to the lawyer. We didn't. You have enough evidence.
They don't have enough evidence. Why did they call us here?
I wonder. There is God in heaven. There is God.
Hello? Yeah?
Which hope is that? Which
Nice one, nice one, nice one. Nice one. This feels good. This feels good.
This push on guy. Almost
Well, God is our strength. It's not over.
I no wan go again.